Okay, so now we are looking at children. Just remember that you might have a client that comes in that is not going through divorce, but yet she wants maintenance for her child, or you might get a gentleman that comes in that wants to have co-parenting responsibilities. So you need to, consider that as well. They might not be married, then you don't need to do a summons and a particulars of claim and all of that. So you just need to adjust according and based on the set of facts, know which court you're going to be going to. So we'll talk about that a little bit later, but previously there has been there's been this maternal favor where the courts would grant custody, so to speak, which we don't talk of anymore, to the mother, because they assume that the mom would look after the child better and all of that. But that is something of the past. It's shifted now from the maternal preference in terms of the Children's Act, and now children need to be engaged with more in order to ascertain what the best interest of the child is. So they need to be considered. So the courts look at the best interest of the child. They consider factors such as the personal relationships between the parties, with each other, with the child as well. They look at the age of the child, the maturity level, and the stage of development. They look at the gender, the background of the child. They look at convenience. They look at what the child's needs are. They look at whether there are any disabilities and any change in circumstances to determine who best the child should have primary residence of. So previously they spoke about custody, joint custody, and access. Now we talk of contact and care. So what they need to do now is they always take into account what the children want to do. There was a particular case where parties got divorced. There was a deed of settlement that was done, and the primary care was given to the mother, in terms of the deed of settlement, and then later on everything was fine. They had adhered to all the terms of the agreement, and later on she met someone and she wanted to move to Dubai, and she obviously tried to get the dad's permission, and he didn't agree to that. So she brought an application for variation, and in that application for variation of the deed of settlement, the courts looked at, they took into account what the children wanted, which was to remain, the status quo to remain, and so they dismissed that variation application, and the status quo had to remain. So they have to look at that as well. All right, and one question for you that I have is, when do you think maintenance of a child stops? When does it cease? Would you say when the child is adopted, self-supporting, or death, right? What about if the mother does not enforce or ask for any maintenance? Does that mean that the parent, the other parent, is not liable or obliged to maintain that child? No, it means that even if the mom is not claiming for maintenance, The dad still has the obligation to maintain the child. That responsibility is still there as a parent. And maintenance would then stop at the death of the child, whether the child is self-supporting or whether the child becomes adopted. So that's when maintenance would cease. Not necessarily when they attain the age of majority, because as you know, a lot of people can't find a job afterwards. They're still living at home, they still require the support. Therefore, that's why they say until the child is self-supporting. Okay, so what does care mean? What does care of a child mean? They look at whether there is a suitable place for the child to live. Does that parent that wants care and contact with that child, does that parent have a place to live for the child, bearing in mind whether the child has any disabilities or what the environment is, people to take care of the child, whether the school is nearby and all of that, what the living conditions are like, whether they are conducive to the child's education and growth. Health reasons as well. They look at health. They look at accommodating any special needs. For instance, if a parent has a house with ramps and the child is in a wheelchair, and everything has been adapted accordingly, and it's close to school and there's a full-time carer, etc., they will look at that and they will consider that is most probably the best interest of the child. So so there's that. Also, if you have a split arrangement of co-parenting and you've signed a deed of settlement, and it's been made an order of court, a parenting plan that's been in place, or whatever agreement that has been reached, and there's a court order, if one of the parties do not stick to that agreement, I know that in a lot of matters, parties, in order to finalize divorces, they just agree to co-guardianship and all of that, and every second weekend the child will go to the other parent, etc. But in reality, sometimes that parent that has whether the child's primary resident, the parent sometimes doesn't then fulfill their part. So the remedy that the other parent would have would then be to approach court for the variation of that. So that's also notice of motion, affidavit, as any application. And then you can also check whether you would, in the circumstances, draft a deed of settlement or a parenting plan. If the parties are not married, there's no reason to do a deed of settlement, so you could just do a parenting plan. You could also do a parenting plan if the parties are married, or you can do a deed of settlement if they're going through a divorce. What is specified in the parenting plan? The parenting plan is there so that you can protect the rights of the child, say what's in the best interest of, make joint decisions about education, schooling, religion, medical details, transport details, that the parents will go to school and get the reports jointly. What about if there's an emergency? Who takes the decision? That both the parents will, if one has to move out of town, or what happens there? Anything to do with the child and the best interest of the child can be pertained in the parenting plan. So this parenting plan needs to be in writing, and it has to also show what the wishes of the child are. You can also talk about maintenance in the parenting plan, the issue of contact in the parenting plan, and that both parents would maybe have regular telephonic conversations with each other about the update, that the child would be able to phone the other parent when they are with the other one. So you can add all of that in the parenting plan as well. And some parenting plans aren't made in order of court, but you can do so. You would attach a Form 8 for registration with the family advocate or the court. You can go through the children's court with that. Don't forget that there is the children's court that's also functional. A lot of the time when it comes to maintenance, and parties might think there might be a dispute, but they want the divorce to be pushed through quickly. Maybe they've got another partner in mind that they're going to quickly get married or so. Then they would go, or maybe they don't even have money for an attorney to fight the issue of maintenance out. You could also agree that the parties will deal with the maintenance in the maintenance court, and that sort of takes out a lot of the fight, and the divorce will go through quicker. And so we'll talk about the maintenance shortly. So the parenting plan is also there for sort of protection, because sometimes parents use children as a power struggle between each other, because they're going through a fight, and they try to alienate another parent. So it's good to have everything written down on basically what they are trying to achieve for their child. Like I've said before, non-compliance in respect of a divorce, a deed of settlement, or a parenting plan, you can approach court for a variation. You can also lay a criminal charge, because now these are court orders, right? Once they've been made court orders. And you can also bring a high court application for contempt. So for non-compliance in respect of the parenting plan, for the deed of settlement, and for the divorce order, because sometimes a divorce order is granted without the deed of settlement. Okay, so if there is a court order for non-compliance, you could the other party can ask for variation, or rather the aggrieved party. Variation, apply for variation, high court application for contempt, or lay a criminal charge. But of course, with the criminal charge, it could turn into a criminal matter, and let's say you've asked for maintenance. This could be a bit of a problem if the person's not able to go out and earn an income. Another thing is that anyone with an interest can bring an application for care and contact, or even guardianship of a minor. So anyone that has an interest, you just have to show that you have a relationship with the child. For instance, a grandparent whose daughter passed away, and she had a child, and that child is now residing with the boyfriend's family or the husband's family, and the grandparents would like to have that relationship with the child. They can also bring an application for care and contact, or even bring an application for guardianship of that child. Okay, so just bear that in mind.